Okay, today is our class on trust, and we're also mixing in some wills so that it's wills trust combined. See some of those problems. The law of trust is like so many other areas of law where it's about where the rules are about relationships between people. And when you have rules about relationships between people, the structure of that area of law is always the same. That is, how do you create the structure that has that set of relationships in it? How do you create the corporation? How do you create a trust? How do you create a will? How do you create a partnership? How do you create a contract? So forth. So one big area is how do you create how do you create the entity that has that set of relationships? And secondly, once you've created the entity, what are the rules for the relationships between the people? If you're looking at a corporation, what is the relationship between the officers, the directors, the shareholders, and the corporation itself? What are the rules about those relationships? And so likewise with trust, once we've created the trust, the question is what are the rules between the trustee and the beneficiary? And then what do you do if someone violates some of these rules? What kind of remedies are available? How do you decide if the rules have been violated? And what remedies are available? And the way you decide whether the rules have been violated is that, first of all, the rules have words, and you need to know how to explain the rule in words. And then secondly, those words have further interpretation by the case law. And so ideally you would know not only what the words are that describe the relationship between the people, but how those words get interpreted by the case law. And then that ends up being the rules for the relationship between the people. Then typically the entity that you create often has dealings with third parties. Let me back up for a second before you deal with that. You may want to amend the relationship, and if you have a contract, you may want to modify the contract. If you have a will, you may want to amend the will. If you have a corporation, you may want to amend the articles of the corporation. If you have a trust, you may want to amend the trust. So you create this relationship. You've got rules about how the parties relate to each other. You know how to amend whatever the relationships are, amend the trust, amend the corporation, and so forth. And there are remedies for when people breach their duties. And then this entity, whatever it is, often has to deal with third parties. A corporation has to deal with third parties. A partnership has to deal with third parties. A trust has to deal with third parties. So you have to know about those relationships of dealing with third parties. Even contracts. The contract does not itself deal with the third party, but you can assign a right or delegate a duty and get a third party into the contract. So then the entity has relationships with third parties. You need to know about those relationships. And finally, how do you terminate the contract, terminate the corporation, terminate the partnership, terminate the will, terminate the trust, whatever it is. And that basically is the structure of all those areas of law. They're very much alike. Today we're looking at trust and mixing in some wills trust because they're so frequently, most of the time, they are tested together. So our first step in understanding the law of trust is how do you create a trust? Well, maybe we need to know what is this trust, first of all. And the answer is that a trust is an artificial entity, like an artificial person, for some purposes. A trust is not an artificial person for all purposes, but for many purposes it is. I mean, a trust doesn't have a right to freedom of religion, for example. Probably doesn't have a right to freedom of speech. Maybe, I don't know about that. But the point is that a trust is an artificial person for many purposes. It can own property, it can sue, it can be sued in its own name, things of that sort. So trust is an artificial entity, and basically it is created by one person. Instead of giving some property to a beneficiary, you hand the property to a third party, and we say, I want you to take care of this property and give it to the beneficiary on the following terms. Now, if you just hand somebody some property and say, I want you to keep this for a week and give this to a beneficiary, okay, that is not a trust, because the person you're giving the money to, the would-be trustee, doesn't have any specific duties that they have to carry out. If I'm just holding the money, and after a while I'm going to give it to somebody else, that's often referred to as a dry trust. It's where the trustee has no duties, and it's not a trust at all. But if I hand the property to you and say, here's what I want you to do. I want you to take care of this property. It's a lot of money. It's $1 million. The amount is not what makes it a trust, but I give you the amount of money, and I want you to invest it, and I want you to take the profit from this money and give the profit to Mary once a month, and then at a certain time, I want you to take the remainder of the trust and do something else with it. Okay, now that's creating a real trust. In that situation, I am the person who is handing over the property to someone else. I am the trustor. And the person I hand it to is the trustee. And the beneficiary is the person who is going to get it. And of course, you can have lifetime beneficiaries, remainder, and so forth. Now, not only am I the trustor in that setting, but I also have another name called the settlor. And I still do not know how the term settlor got to be used in place of trustor, but either of those two terms will work. So our first step is in how do I create this artificial entity called the trust? And the answer is that there are 6 requirements, and they are on the board. To create a trust, the requirements are intent, purpose, res, a settlor, which is a trustor, a trustee, and beneficiary. The problems are start here with the intent to create a trust. Now, you can hand people property and say, ask them to do various things with the property, and if you say, I am giving you this property in trust, and here are the terms of the trust, here's what I'd like you to do, then that expressly shows intent to create a trust. Take this, I hereby transfer Blackacre to you in trust. Here's the stock, I give it to you in trust. And so, if I can have the express intent to create a trust, and that works, but if I say, here's half of the property from the estate, and I would like for you to use this property to take care of your sister, take care of your mother, take care of your brother, whatever it may be. I hand you this property, and I want you to use it to take care of this person. Well, is that really a trust or not? Obviously, if I became a lot more specific, and I say, here is this property, and I didn't use express language. I didn't say, here is this property in trust. Okay, I didn't do that. I said, here is this property, and I would like for you to use it to take care of Joe for life, and then give it to Mary after that. Well, is that really creating a trust? I didn't use the word trust, and so you can see how you need to look at some factors to try to figure out whether or not the person really intended to create a trust when they failed to use express language. And the language that doesn't quite make it to express language is called precatory language. And so if the person who is the supposedly settlor used precatory language so that they did something like what I said to you, then you have to try to figure out, did they intend to trust? And so what factors would you use in trying to figure that out? And they're pretty much common sense factors, but let's talk about some of them. One of them is, of course, how specific was the language. The more detailed language that I give to the person, I said, with this money, I want you to do these 5 things and so forth. The more complicated the instructions are, the more specific they are, the more likely it is that I intended to trust. So there's one factor, how specific is the language. Another factor you would use is whether or not there's been a history of support. In other words, if I have been supporting this person, for a time, let's say it's a disabled relative, and I've been supporting this disabled relative, and then I give you some money and tell you things I want you to do for this disabled relative, well, my previous support sort of suggests that I intended to continue that support, and I wanted to formalize it in giving you the money and making a trust. So prior support of the beneficiary is another factor that you would use in trying to decide whether or not a trust has been created. So far we have two factors. One is how specific was the language. Another one is prior support of the individual. Another factor is whether or not the person to whom I gave the money, the person I'm making the trustee, if that person is an institution, like the Bank of America Trust Department or something. If it's an institution, no matter what I said to the institution, it's almost surely intended to be a trust. But if I give this money to a person who I might naturally make a gift to, and then give this person all that instructions, well, you can see now the person has a double role. This comes up all the time in the legal system where people can function in more than one role, and they do something, and the question is, well, which role were you using at the time? You see it in community property, where a member of the community can own separate property, and they can have community property in their name. And when they have property in their name, is it really their separate property, or is it community property? You see it just every place where a person can have more than one role. Which role were they in at the time? And so the same thing happens with the trust situation. If the person to whom I'm giving the money, handing the money if that person only has one role, because they're the Bank of America Trust Department, I don't have a problem. But if that person is a close relative, so I might have been making an actual donation to them, and I might have been giving it to them in trust, now you've got a problem. And so sometimes the status of the would-be trustee helps you decide whether or not it was a trust. Other times the status of the would-be trustee just confuses the picture so much more. So those are some factors. Other factors that you can use sometimes is, one more factor is, would it produce, is a very important factor, would it produce an unnatural result if I do or don't make this a trust? I hand you money, let's suppose that this person, in the real problems, this person does it in the will. And the will, the person says, this person has two children, and they hand all the money to child number one, saying, I want you to look out for child number two. Well, obviously, the person wasn't trying to disinherit child number two, because they said, I want you to look out for him. And so, if you don't make that a trust, so that the money you gave to child number one, saying, please look out for child number two, if you don't make that a trust, then you get an unnatural result, where all the money was given to one child, when obviously there was no intent to disinherit the other child. So an unnatural result, would it produce an unnatural result, is a big factor. And the ones on the bar exam have used that factor probably more than any other factor. If I make this a trust or don't make it a trust, either way, would it produce an unnatural result? So those are some factors that you would use here when you have precatory language. Would it produce an unnatural result? How specific were the instructions? The status of the person to whom you are giving the money, and the prior support, if there was prior support. So those are the issues of intent. Purpose. The purpose of a trust can be any lawful purpose. It doesn't have to be some lofty, noble purpose. Just any lawful purpose at all will do. A person wants to support their child, wants to support a disabled relative, wants to give money to the Boy Scouts, whatever you want to do, doesn't matter. So any lawful purpose. If it is a charitable trust, then of course the purpose in a charitable trust needs to be a charitable purpose. So we'll have a branch here for the private trust versus the charitable trust here. And for a private trust, any lawful purpose will do. For a charitable trust, you need charitable purposes. The res of a trust. This is the corpus. This is also called the corpus of the trust. And the res of the trust can be any recognized interest in property, however contingent. Any recognized interest in property, however contingent. Any recognized interest in property, however contingent it may be. So that, for example, if a person is going for an airplane ride on a commercial aircraft from here to New York, and he used to be able to buy these flight insurance at airports. And let's say the person stopped at one of those machines at the airport and bought some flight insurance. And the flight insurance pays $1 million if the airplane crashes. Well, that flight insurance is a highly contingent interest. In other words, airplanes don't crash very often. So it is extremely unlikely that that insurance policy will ever pay off. But if you do that, and that insurance policy can be put into a trust. It can be the only res of the trust, the only corpus, because it's a recognized interest in property, highly contingent, but it will still serve as the corpus of a trust. In real property, you can have future interests which are exceedingly contingent, and all of that stuff is perfectly okay. It can still be the res of a trust. Now, the kind of things that cannot be the res, that cannot be the corpus of a trust, are things like your hope that Aunt Mary is going to leave you some money, and the hope that you're going to get something from the will. Even if Aunt Mary has made out the will, she can change the will as much as she wants to, and so that hope that you're going to get something from the will simply is not a recognized interest in property, and that cannot be the corpus of a trust. It's not even property. Next, the settlor. This usually does not present a problem. The settlor is the person who is parting with the money. Now, usually the settlor is giving away money in a trust. It's not a trade usually, it's a gift. The person is saying, I will put this money in trust for my whoever they want to take care of, and it's a gift. So usually the settlor is making a donation. It doesn't have to be though, because the settlor can say, look, I owe you $500,000. And instead of me paying you the $500,000, here's the check right here. Instead of me handing you the $500,000, if you are agreeable to it, what I will do is I'll put this $500,000 in trust. I'll hand it to a trustee and tell the trustee to dole it out to you on certain terms. And if the person says, yes, I'd like you to do that, then you do that, and now you've created a trust. But and the person discharges a debt to me when I hand the $500,000 to the trustee. So my point is that when I create the trust, it doesn't have to be a donation, but it usually is. Now, one of the things you want to watch for, if it's not a donation, it's not a gift, is that if I owe you $500,000, and I say, okay, if you will discharge the debt, I will put this money in trust for you on whatever terms we've agreed on, and you say, fine, it's a deal. And I put the $500,000 in the trustee, and you discharge the debt to me. Now, what's important to realize is that that's your $500,000. That's the same thing as you taking your $500,000 and putting it in trust. And the reason that matters is because if you try to put a sensitive clause in that trust, you can't put your own money beyond the reach of your creditors by putting it in a sensitive trust. You take your own money, put it in a sensitive trust, and the creditors can still reach it. But if I'm trying to donate something to you, and I put that in a sensitive trust, most states recognize sensitive trust, and your creditors cannot reach it. We'll talk more about sensitive trust in just a few minutes, but you see the point that you have to distinguish whose money it is that went into the trust. When I put the money I owed you in the trust, that's really your money. If I'm really donating to you, then it's my money. So the settlor trustee is usually not a problem. You can be your own trustee. You can put your own money into a trust put your own money in trust. You can be the trustee of your own money, but you cannot be the only trustee and the only beneficiary. Okay, if I'm the only trustee and the only beneficiary, the whole trust kind of merges and I don't have a trust anymore. But I can be the only trustee if there are two beneficiaries. I can take my own money, $1 million, put it in trust, and I say to my child for life, remainder to my grandchild. Okay, well I can do that if I want to, because well, I mean, I can better than that. I can take my own money, put it in trust, and say to me for life, to myself for life, income to myself for life, remainder to my child. And so if I do that, I'm not the only beneficiary. And so it's okay for me to be the only trustee as long as I'm not the only beneficiary. I can even have two beneficiaries and two trustees who are the same people. I can say $1 million to A and B, and A and B are the trustees. Income to A and B for life, remainder to, I don't know, whoever. But the point is that even if I just said income, if we don't have a remainder, it's the kind of trust that ultimately after 10 years I'm going to give it to A and B. So if I have the trust money and it says I give it to them and says to A and B for 10 years and then give the remainder to A and B. And A and B are also the trustees and A and B are the only beneficiaries. Well, A and B can be the only beneficiaries and the only trustees, and that's okay. That's perfectly okay. Now, so the trustee is usually not a problem. The beneficiary, normally the beneficiary is not a problem, but the one kind of problem that you often end up with the beneficiary here is where the beneficiary does not yet exist. You try to give something to the firstborn child of Mary, and Mary doesn't have a firstborn child yet. And so if you say you try to give something in trust for the benefit of the firstborn child who does not exist, you try to give something in trust for the benefit of a corporation that does not yet exist, for the benefit of a partnership that does not yet exist, for you give anything in trust to some entity, and a person or entity that does not exist yet. And in the old days, those trusts would fail. Okay, but that's not true anymore, and that's important. That if you do that, what happens now is that you wait. If I have the money, say to A in trust for A's firstborn child, and then I give some terms of, give the income to the firstborn child and what to do with the remainder and all that stuff. But the important thing is the firstborn child doesn't exist yet. So what happens is I give money to Mary, okay, for the benefit of her firstborn child. She doesn't have one. She keeps the money. The policy is Mary holds on to the $1 million, and what she does with the $1 million is that she invested and does all the things that a trustee is supposed to do with that money, okay, etc. But there's no firstborn child. And normally the beneficiary requires that the trustee account for the beneficiary once a year. So every year the trustee goes to the beneficiary and says, here's what happened to your money last year. That's the accounting that they have annually. Obviously, you can call for an accounting sooner if you got reason to. But otherwise, the accounting is annually. But there is no firstborn child of Mary to call for this early accounting at all. So what happens annually is that the trustee, the money that I'm giving to Mary has to account to me, settlor, every year. I'm the person who would see to it that Mary conforms to the terms of the trust. I'm the person who would sue Mary if she failed to conform to the terms of the trust. But I don't get any of the money. Okay, and when the firstborn child finally comes into existence, now that person becomes the real beneficiary, and they do all the things that beneficiaries do, and I, the settlor, am completely out of the picture forever. So the formal language that you use to say all that is when I give the money to Mary and there's no existing trustee, we say that Mary holds the money as a trustee of a resulting trust. She holds this money. Remember, a resulting trust is the kind of trust where the trustee basically has to give the money back because you can't carry out the terms of the trust anymore. And you basically have to give the money back. And while this trustee is holding on the money, waiting to give it back, we say that trustee is a trustee of a resulting trust. And so when I give this $1 million to Mary for her firstborn child who doesn't exist, she becomes the trustee of a resulting trust, subject to the springing executory interest of the unborn child. So she becomes the trustee of a resulting trust, because she may have to give it back, but she won't have to give it back if the firstborn child comes into existence. So this resulting trust is subject to the interest of this unborn child. So we say subject to the springing executory interest of the unborn child, of will of the non-existing beneficiaries. And those are about the only problems that come up with beneficiaries. Now, so we understand how to create these trusts. Let me show you an example or two of the creation of a trust. One of the best examples of this is not one of the questions that was assigned for today, so I want you to look at it quickly. We won't necessarily do the whole question, although we might, because it's such an excellent question for these purposes. And the question I would like you to look at for these purposes is here. It's from the February 1979 bar. Now, it's an older question, but that's kind of irrelevant if a combination of facts presents a good illustration of the issue. That's what matters. In this question from the February 1979 bar, February 79 bar, if you take a look at that question, and here's how it reads. And what this question is about, the reason we are using this question, is because this question is going to give us a good illustration of this stuff here. And we need a good example. This is one of the best examples that I've ever seen of all the bar questions that have ever been out there. Line 7. Fred, a widower, so get a good image now. Fred is alive, his spouse is deceased, and he died, survived by 2 children. So Fred, the widower, just died and left 2 children, Bob and Tom. Bob and Tom. Okay, those are his 2 surviving children. Bob had just been divorced from Susan. Okay. And was heavily in debt. Okay, so if Fred left half of his estate to Bob, the creditors would just come and take it away. So he doesn't want to leave it to Bob for that reason, and so he's going to try to protect Bob's interest in some way. So he says, by his will, line 8, by his will, Fred left all of his property to Tom. Okay, now right away you're saying, well, he left all of his property to Tom. You say that's an unnatural result. Okay. Now, if he's mad at his child Bob, if he's mad at Bob and wants to disinherit Bob, that's fine. But if you read on, you see the situation. He says he left all of his property to Tom with the quote, request that from half the property. Request that from half the property, Tom pay to Bob, a bunch of money and stuff. The details of how he's supposed to pay to Bob is not important right now. The question is, do we have a trust? And so intent Well, he didn't say, I'm giving the money to Tom in trust. He says he gives all the money to Tom with a request that you use half of it. So you've got precatory language. And if you have this precatory language, did the settlor really intend to create a trust? Well, let's look through some factors. Number one, would it produce an unnatural result if you fail to make a trust out of it? Yes. It would produce an unnatural result because one child would get all the property, and obviously Fred was not trying to disinherit the other child. So it would produce an unnatural result. Secondly, prior support. Well, yeah, people have previously supported their own children, so you got prior support. Third factor, is the person to whom you're giving the money a person who wears two hats or just one hat? And the person he's giving all the money to is Tom. And Tom is his child, and he might have given all the money to Tom. So Tom's got two hats. Tom isn't like the Bank of America, where the only reason you want them is you're sure they're a trustee. You're not donating to the Bank of America. And so Tom has two hats, and so that confuses the issue a bit, because the settlor could have intended to just give it all to Tom. So that's another factor. So those are factors that you would use. How specific are the instructions is another factor. I didn't read you the rest of the details because they're not important here, but you can look at the rest of the instructions and you can say, well, they look like they might be specific and maybe they're not, because there's some vagaries in there. So you pick a point from the bar by pointing out whether the instructions were so specific that the specificness of the instructions themselves suggest that the person was creating a formal trust. And it's your discussion about that we get the point. So that's what you would do with this problem of intent. The purpose of the trust in this case was to help out his son. That's a perfectly lawful purpose. That's all you need. The corpus. Now the corpus presents a problem in this case because, well, in this case it doesn't, but it could have. The corpus of the trust, as I say, must be some recognized interest in property, and you have to deliver this recognized interest in property to the trustee. Just like you have to deliver a deed in order to effect the conveyance of property, well, you have to deliver this property to the trustee. And the trustee can be yourself, so the delivery can be quite easy as soon as you segregate it out and designate it and notify the beneficiary that you've done this. So you can deliver to yourself, you can deliver to somebody else. But the problem is that if the person writes this trust in a will and says in the will, half of my estate to Joe. Well, if the person says half of my estate to Joe, and the person is deceased, the court can identify half of the estate and give it to Joe. Because if the parties are in dispute about what half of the estate, you can just sell it all. So you sell it all and give half the money to Joe. So if the person is deceased, you can determine what half of the estate is and give it to him, whatever it takes to do that. But suppose the person is alive, and this is an inter vivos trust. So you're creating it while someone's alive. And while someone's alive, the person writes a note and hands this note to Frank. And says, the note says, to Frank, 1/2 of my property in trust for Joe. Well, if it's a living person, you give him a note and says 1/2 of my property, that is not delivering any particular property to anybody. Okay, you can't take that note that says 1/2 of my property to Frank in trust for Joe. You can't take that to the bank and get half the bank account. Okay, you don't end up owning, it isn't delivering any specific property to the trustee. The trustee doesn't have anything that they can manage, take charge of, invest, do all the things that trustees are supposed to do. And so so you have to deliver the property. Now, in a will, as I mentioned, that's easy to do. But if you give fractions of an estate to someone inter vivos, you try to give them fractions of estate, you don't get anything. So in a will, you can say half of my property to Frank in trust for Joe. Inter vivos, you cannot say half of my property to Frank and trust for Joe because you haven't identified any particular one half of the property. You can say my car in trust for Joe, but not one half of everything I own. So these fractions of an estate will work in a will. If it's a testamentary trust, they will not work in an inter vivos trust. Now, in this problem that I just read to you, what it says is all my property to Tom, and I request that. The request that is the precatory language that we have to now apply these factors to. So with a request that one half of the property be used for the benefit of Bob. Well, one half the property right here, we said one half of the estate. Well, that's okay because this is in a will, so this works. The settler in this problem was Fred, the father. The trustee, if there was one, was Tom, and the beneficiary was Bob. So that's an example of creating a trust where you had to deal with these kinds of issues. Now, most of the trust has been created, and these are the issues that can come up. Again, the big issues are right here: precatory language, factors you use, this business of using, do you have any real problem here, and delivery. We don't have a problem regarding delivery, but you can see the problem if you don't deliver the trust property, then the trust hasn't been created. So if you want to create a trust in your own, you want to create a trust for your child Mary, and you want to create a trust for your child Mary, and you want to give her the $100,000 that's in the bank savings account. It's in the bank savings account in your own name right now. And so what you do is you transfer that to yourself as trustee, and you notify the beneficiary that you've done this, and you now have delivered the property and created a trust. But the delivery of the property really happens when you change the name on the bank account, and that amounts to delivery to yourself. Now, once we have created the trust, and these are the key issues. This one is a key issue. This is a key issue. Delivery is a key issue, and the only other key issue here is this problem that comes up sometimes: who is the settlor? Because if I owe you $500,000 and I say to you, if you will discharge the debt to me, I will put this in trust for you. That's your money that went into the trust, and the censor clause won't work, so that comes up sometimes. These are the key issues that come up in this area. Next, we come to, once you have created the trust, people often want to protect the beneficiary against the beneficiary's own improvidence, against their creditors. So how can you create a trust and do things to help protect the trust property against the creditors of the beneficiary? Well, first of all, please keep in mind that if the beneficiary has creditors and you don't owe those creditors anything, if you're going to be the settlor, you don't owe the creditors anything. So the devices that you use to try to keep the creditors from getting the money before it gets into the hands of the beneficiary, you are not defrauding anybody's creditors because you don't owe those creditors. Those are the beneficiary's creditors. So, for example, if you have the $500,000 in your possession and you say to the beneficiary, I am going to donate this to you. Well, the beneficiary's creditors can't come to you and say, we heard that you are about to donate $500,000 to the beneficiary. Pay us first. Well, they can say that, but you don't have to pay them first because the money doesn't belong to the beneficiary yet. So you can see that if once I hand the money to the beneficiary, then the creditors can go after it. And no matter what the beneficiary does, they can put it in the bank and hide it under the mattress and so forth. If the creditors can find it, they can go after it. But as long as I've got it, it's still my money. The creditors cannot go after it. So now, suppose instead of me saying I'm going to give this money to the beneficiary, suppose I say I'm going to give it to the beneficiary by way of a third party. And if I hand this money to a third party and I say to the third party, give this money to the beneficiary on the following terms, income for life, remainder to somebody, or whatever my terms are. If I give it to the beneficiary, give it to the trustee, and say, give it to the beneficiary on these terms, should the creditors now be able to get this from the trustee? Because I put the money in there, and it hasn't been given to the beneficiary yet. Are you going to let the creditors go after this money in the hands of the trustee? The creditors couldn't go after it as long as I had it, but once I give it to the trustee, I can't get it back, but the beneficiary can't get it either. Well, the beneficiary can get it if the trustee is supposed to pay, say, $10,000 per month on the first of every month. Well, as soon as the first of the month comes around, the trustee now at that instant has $10,000 that belongs to the beneficiary. And so the creditors should be able to go after that. Every time the trustee ends up with some money that the trustee is supposed to deliver to the beneficiary, the trustee at that moment has property that belongs to the beneficiary. The creditors can go after it. But they got to get to it before you hand it to the beneficiary. Now, are you going to let this person, the creditors, go after the money in the hands of the trustee or not? Okay, and that's what the Spencer Trust are all about. So let's talk about these devices. For trying to protect right here, devices that are used to protect against creditors, protect the beneficiary against creditors. Here, let's pull this over on this board a little bit. Devices to protect the beneficiary against their own creditors. Now, there are a number of devices that are used for this purpose. Spencer Trust is one of them. Discretionary Trust is another. Protective Trust is another. Support Trust is another. And the Blended Trust. And we want to talk about each of these and give some examples of how they work. However, we're getting close to our break time, and rather than starting on this new subject right now, what we'll do is we'll take 10 right now, and then we will pick up and start in these subjects.